This is Steve Keist, attorney in Glendale, Arizona. The process for obtaining a child support award differs depending upon your circumstances. If you are obtaining a legal separation or divorce and there are minor children of that relationship, then child support will be determined by the judge who is assigned to your case as part of the overall either settlement or adjudication of the case. If that happens and it's not a 4D case, in other words, you're not receiving some type of public benefits, then the judge ultimately will enter an order ordering child support. Child support payments are made through the clearinghouse, which is an organization. It's a division sort of the clerk's office in the Maricopa County Superior Court. And they do all the collection and accounting for child support, and they can provide calculations for you, and you can even now go online and obtain updated statements that show the status of any child support order and collection, which would list all the payments and if there's an arrearage. In order to obtain child support, if you're not doing it as part of a total divorce or legal separation, you would need to separately file a petition asking the court to order child support. It could be as part of a custody request. It could just be if there is no custody issue and you have kids, there's just never been a support order entered, you can apply for support at any time. The law provides that minor children are entitled to support and that parents can't legally waive their right to that support without a court sanctioning that waiver. So even though you may have told the other parent, I don't want any support, and a period of time goes by and you determine that you need the support, you still have the right to go back to court and ask the court to order it. Child support will be ordered for minor children beginning the first day of the month following the time that you file the paperwork with the court and have the other person served with that paperwork. So for instance, if you filed the paperwork in February and the other person wasn't served until in March, the effective date of the child support order would be April 1st. Child support can be retroactive if you have had custody of the children, or if it's a young child, if the child's never been subject to a support order after its birth. The court can go back 3 years in ordering child support. So at the time you ask for it, if it's effective April 1st of 2010, for instance, the court could order child support back effective 3 years prior to that date. In exceptional circumstances, the court can order support to go back farther than that, but generally speaking, by statute, child support orders are only retroactive for 3 years. So if you are someone who's in a position where you need support and you've been putting off asking for it, you should do that, because you may be limited to only going back 3 years, even though the child may be a lot older than that and you've never received support. So the process, if it's not part of a divorce or legal separation, you can file separately a petition for child support, and the court will set an initial hearing. If you file the paperwork on what we call an expedited basis, those forms are available through the court website or from an attorney. They will set an initial hearing, if you will, but if no answer is filed by the other party, which disputes your child support calculation, then they can just enter the order without having that hearing. If the other parent disputes the child support calculation that you've made, and you will have to file a worksheet showing that calculation when you request relief from the court, then the court will set an initial hearing, and you will actually have a meeting with representatives from the Department of Economic Security Division of Child Support Enforcement, who will sit down with both of the parents and try to figure out what is the appropriate support amount and whether there should be any retroactive application. If you can all reach an agreement, then the representative from the Attorney General's office will put that agreement in writing. You'll both sign it, they'll send it up to the commissioner, it'll get signed, and you're done. If you can't reach an agreement, then you will have a hearing that day, usually the next hour, with the commissioner assigned to the case, and the commissioner will hear the evidence and decide what the child support obligation should be and when it should start.